Okay, Mr. Chavez, we are now live.
Great. Thank you, Mr. Moya. Good morning, folks. We are on the record. Today's date is April 1st, 2021. I'm Stephen M. Chavez, the city's land use hearing officer. This is a time-sensitive quasi-judicial administrative appeal from a decision, it looks like, of the Landmarks Commission. This is numbered AC-21-3. This hearing is also being recorded by a certified court reporter. Good morning. The procedure for this appeal is as follows. The appellant will make an argument. I will swear everybody in, of course. Then the party opponents will make an argument if there is a party opponent to this appeal. Then the city planning staff, if they choose, can make their record in this appeal. I do have questions for staff if they are here. Then the appellant will be allowed to make a closing rebuttal argument. And then we will, let's see, I want to see, are there any supplemental documents that we need to include in the record before we get started? Mr. Gleason, are you here?
Yes.
Yeah. Good morning, sir.
Good morning, Mr. Chavez.
Before we get into the merits, I just wanted to ask you the simple question. Are there any supplemental documents for the record that you would like to include in that record?
The only supplemental document is the actual presentation that I'll make today that we had submitted on Monday.
Okay.
Or Tuesday, sorry. Prior to the
I haven't seen that for some reason. It wasn't sent to me. So it's basically just your factual arguments? Correct. Okay. Okay. I hope to get a copy of that soon. I did not get a copy of that. But certainly, are you going to share your screen so I can?
Yes, I'd like to share my screen. Yes.
Absolutely. No, I don't have a problem with that. Who is here with the planning department? There is nobody here with the planning department. Okay, well, it's their prerogative. Well, let's get started. Mr. Gleason, let me swear you in. For the record, Mr. Gleason's full name is Will Gleason, correct, sir?
William Gleason, to be more formal.
Yes, of course, William Gleason. And raise your right hand. Do you swear or affirm to tell the truth under penalty of perjury?
I do.
Wonderful. Thank you so much. Let's get started, sir.
Sure.
I have read the entire record except for the supplement that you indicated.
Great. Let me share my screen here. All right. Can you see that?
I can see it. Thank you.
Great. Good morning, Mr. Chavez. We would like to have a brief presentation on our appeal of the denied demolition permit. This is for 611 Cole. As you know, this site is outside of a historically designated area, but it does fall under the purview being within the downtown area. The project site is about, it's about a third of an acre, it's about 17,000 square feet total. The western half of it contains the subject building, that's 611 Cole, and the eastern portion of the lot is vacant. And just by way of context, the properties, the multifamily that is to the west of this was developed by the property owner. It was originally intended that this was going to be part of that project. It didn't end up being part of that project. The current owner has owned it for more than 10 years and is trying to work with the county to develop it into housing for veterans.
Mr. Gleason, I apologize in advance for interrupting you, but I do need to interrupt you and ask you, when you started your presentation, you essentially requested that I rehear this. I don't have that authority to rehear this matter. This is not a rehearing. Essentially, it's to determine whether or not the Landmarks Commission erred in some way, in some respect, under the IDO. That is, whether it erred under the law, whether it erred under the facts. I can tell you right now that it's my belief that the Landmarks Commission erred grossly. They didn't do what their authority requires them to do. There are only 3 things they can do. And I know that you requested in your application that they not issue or not review it for a 120-day review period, but I don't think they have that authority to not look at that issue They only have the authority to either postpone the hearing, but that is by written agreement of the applicant. They have the authority to make a determination of no feasible alternative, which would lead to the demolition which you're requesting. And then they have the authority to invoke the 120-day review period. And then there's lots of guidelines that are required that need to be followed during that 120-day period. But they don't have authority to just outright deny the application. It's very clear to me in the IDO. I read that section 6.6b several times, and I know I don't hear these very often. In fact, I think I've only heard 3 or 4 in the last 16 or 17 years. And so my concern is that the Landmarks Commission erred because they denied the application, kind of sending you into the abyss. There's nothing you can do now with this application or with your request. And I think it seems to me that's what the city council intended to avoid by creating this elaborate policy scheme of how to deal with these applications in the IDO. And it is quite an elaborate schedule of things that need to be done. So if you could focus in on those issues,
yes.
Okay, good.
I understood. And Mr. Chavez, I completely understand that this is an appeal, and we're not retrying this. So yes. Okay, I will get to the point here. So project site, we know that. You saw the from the history. This is what was transpired prior. Code enforcement had issued a substandard building violation. Code enforcement has had a lot of issues with this particular property.
What does that mean when code enforcement issues a violation? Is it because it's dilapidated and they cited you criminally, or is it an administrative process?
I believe it's an administrative process, but I am not entirely certain about that. So
it hasn't gone anywhere except for the citation.
It is a nuisance. I mean, there's homeless living in it. Vincent Montano has had to, have calls there repeatedly on a weekly basis. So that it was issued for demolition. The city said, we're going to demolish this property. So, and so that's what really started this whole chain of events. So, and then the criterion 1, we believe that the Landmarks Commission erred in terms of its classification of this property, that it is not a brick building per se. It is a wood frame over a first floor of brick. So it is not both stories are not brick. We did some more research on this and have pretty good evidence of that. The second floor is wood framing. So, and it's a different, it's not as rare as we think that the Landmarks Commission was making it out to be. And then we have multiple examples of other examples of this type of construction that are in much better shape throughout the city. So here's one on Edith. Here's a couple on Cole, and these are all in better condition. Here's a couple on Iron and Hazeldine. So we just went out and we found a lot of examples of this type of architecture that are much better preserved than 611 Cole is.
These are also in the record, yes. Not supplement, but the record. Okay.
Yes.
Right.
Yes. And then criteria number 2 about contributing to the city's economic development or tourism industry. Clearly, it does not contribute to the tourism industry. The Landmarks Commission asserts that it could be used for housing. It's a tough sell that way. It's the cost to remediate the property is exorbitant, and the return would be minimal. So it was rented out for a number of years, and it's when the property owner wanted to redevelop the property that the troubles really began. So
but tourism is more than housing. I mean, it's not tourism is to use for tourists, potentially for their housing, not just for housing in general for city residents, correct? I mean, that's what that criteria speaks to, tourism.
Yes, right, exactly. It's not about housing. And so if it's if it's an amaze like the chemo, I would argue is absolutely contributes to tourism. It's a really rare form of architecture and something that people would definitely have an interest in. This structure, I don't think you're going to attract a number of visitors from outside the area to go look at this.
Yeah, I mean, I think there's a level of speculation that's allowed in the IDO for the Landmarks Commission. It's kind of carved out into this section, but that speculation can only go so far.
Yes,
and it seems to me that finding was entirely speculative because there were no findings of fact to support it. And so I agree with you on that.
Okay. And then, sorry, I went a little too far here. 3, the structure's potential to enhance the city's heritage and historical identity. Again, we feel like that the modifications of the property make it so that it's really not that contributing to the city's heritage and historical identity. Particularly the entire building having been stuccoed, the addition of porches. It's just the original condition of the property is greatly compromised. So we appreciate that it was built at the time of the rail yard, but it's not the best example of what that architectural era has.
Didn't the city planner agree with you on this point?
Yes.
In her report? Okay.
Yes, and her original recommendation was for demolition, for a demolition permit.
Correct. Right.
So that was changed during the course of the hearing. So moving on, these are showing those modifications. I don't know if you need to look at those or not.
I did read the record quite closely, and so I note that everything that you're presenting is already in the record. So
okay, great.
I have a question, but
yes.
I'm sorry.
Go ahead.
My question is regarding the chief building official, which this section speaks to, and it requires the city to notify, and I didn't quite understand that when I first read this section, but then when I read the entirety of the Landmarks Commission purpose and duties under this section, it was clear. So it seems to me that the chief building official was required to have been notified in writing of your application. And that notification needed to go to that official within 15 days of your application. And then the hearing is within 60 days of the application. And it was required to be in writing. So I didn't see that in the record. Do you know if that official was notified in writing of your application?
Mr. Chavez, I do not know if that building official was notified or not. I think Leslie Najee would have a better sense of that.
Is she here today? I didn't see her on.
She was on when I first got on, and then but I don't see her either. It might be that Jennifer Fascio, who's also with Deca Paris Sabatini, could answer that question.
Okay. Well,
there's Leslie.
I am. Yeah, I am on.
Ma'am, before we get to you, let me finish with, thank you for being here, by the way. But I want to make sure that Mr. Gleason has his opportunity, and then if you can still stay on, I'd like to ask you some questions under oath certainly regarding the building official. Thank you. Mr. Gleason, proceed, yes. Please.
Okay. So that's criterion number 4. And then the structure's condition. We do believe that we know that there are serious issues with this property. We had one of our architects go out and inspect the property specifically for its structure. There's some serious settling on the north side. There's evidence of asbestos. As you've seen from the interior photos, the interior is pretty trash from homeless living there. And the floor structure and wood ceilings and the porch are all compromised.
Right.
And the owner has spent, excuse me, yes?
No, go ahead. I'm sorry. I apologize. Sometimes I interrupt so that I
That's
don't
okay.
my thought. Again, thank you. It seems to me that these issues are very important for the Landmarks Commission to decide under this ordinance whether or not that 120-day period should be invoked. And because these are the negotiation issues, the leverage for the city and for the applicant to get something done, either a landmark or demolition, one of the two. But with a denial, it seems to me, and that's kind of the policy that's written, that's suggested or implied in this elaborate scheme of things under the IDO. It's that the 120-day period is so that the city has some leverage, and so that the applicant has leverage to get what they want, so that there can be a good faith negotiation between the two. And it seems to me a denial just kind of vitiates that, takes that away entirely. And that's my concern. So anyway, I did, again, Mr. Gleason, I did review all this in the record. So
Great. Okay. And then just this was not in the record about that the owner has spent over $55,000 in repairs and maintenance of the property.
Okay.
And that's all well documented. Can I ask a question though about the 120-day period? With whom would we be negotiating the resolution of this? Would it be the Landmarks Commission?
You know, it's not quite clear. But I'm just going from what the IDO says, and the IDO says the city can negotiate. Certainly, the city can negotiate through the Landmarks. I don't know what it routinely does, so I would be uncomfortable with saying that. But I can tell you that in the IDO, it's very clear that there is only three manners that the Landmarks Commission has to deal with this application, and that one is to postpone a decision, but it can't do that unless it has your written agreement, the applicant's written agreement. The other one, of course, is to make a finding of no feasible alternative, and which would go straight to demolition, I would expect. And then the third is to invoke the 120-day period to essentially, it says, to foster negotiation with the city on what to do next. And those things are either demolition or landmarks or preservation or rehab. It seems to me that the Landmarks Commission denied the application so that it could try and preserve it. I don't think it has that authority under the IDO. I think that it has the authority only to invoke. So anyway, does that answer your question, sir?
Yes, it does.
Okay.
Yes.
Okay.
Okay. And then the last part of this presentation, and it might not be germane. I mean, here's some of those structural issues that I was just referring to. You can see some of that damage, the rotten wood, the interior. And then this is what, so to your central point here, Mr. Chavez, we understand that there really are three alternatives, and the denial is not one of them.
And I think, in their defense, I think that they were confused with your request to bypass the 120-day, so yes. They didn't know what to do with it. So I think you contributed to the confusion.
Yeah, thank you. And then just the last bit is, this is what is being proposed there. I know it's not really germane to your decision at this point, but just by way of information, it would be 45 units of 45 units designated for homeless veterans. So that is the intent here. But the county cannot move forward with this until that property has been remediated. So. Right. And then that's it. Thank you.
Okay. So regarding you said you had an associate with you who might be able to answer that question regarding the building official?
Yes, that would be Jennifer Facio.
Would you like her to
Sure.
testify before I move on to the planning staff? Okay. Ms. Facio? Did I pronounce her name correctly?
Yes, you did.
Okay. Is she here?
Yes, this is Jennifer. I do think
Let
Leslie.
me swear you in first, okay?
Oh, sorry.
Okay. And for the record, please state your full name.
My name is Jennifer Fossio-Maddox.
Good morning, ma'am. Now, do you affirm to tell the truth and only the truth under penalty of perjury?
Absolutely, yes.
Thank you. Go ahead. Thank you.
I am not 100% certain about the code enforcement connection. I do think the process was for the planner, and that would be Leslie Nagy, who is also on right now, and she'll be able to speak to whether or not that was submitted formally to the code enforcement director. We do have a lot of documentation from code enforcement regarding the status, but nothing from the official.
Okay. Because I mean, once the official gets notification, it's my understanding from the IDO that if the official had not received notification, you can obtain a demolition permit without, regardless of what the Landmarks Commission does. It seems to me that the IDO kind of leaves that open for you to obtain, which is a little strange, but I kind of understand the policy rationale behind that, but it clearly says that. So it's important that we know whether or not the building official has received the notification as required. But thank you. Is there anything more you would like to add?
No, I think to your point earlier, Mr. Chavez, I think the position that we're in now is that abyss that you mentioned. It was like that the denial has given us nowhere to go. If we are given the permission to go to the building official and it's their decision, then that is great. That's a path for us to move forward with. But just the straight denial was it didn't leave us any direction.
Well, under IDO section 6-6B2D, D as in dog, it essentially says if the chief building official did not get the notification as required, that the city can issue the demolition permit. I don't know exactly what that means, but it sounds like it means that, hey, if things weren't done correctly, then the demolition can be applied for directly through the city.
I have spoken to the local code enforcement whose area this is for them to cover, and asked about that route as well, because the city did issue a demolition notification, and they said they also would have to go through this process to get their demolition permit as well. So
yeah, and I know this IDO process is very different from the previous ordinance, not the previous IDO, but the previous ordinance. And so maybe everybody is just stuck in that routine from before. But anyway, we'll go ahead and proceed. Mr. Gleason, can you take your
Yes.
sharing off so
Yes.
that I can see people? It's kind of hard just to speak to my computer screen. Okay, good. Thank you.
Thank you.
Miss Najee, is it Najee?
Naji.
Najee, thank you. Let me swear you in, ma'am.
Okay.
Do you affirm to tell the truth, only the truth, under penalty of perjury?
I do.
Thank you. And for the record, your full name?
Leslie Naji.
Thank you.
I'm the senior planner for historic preservation for the city of Albuquerque. Just to clarify the confusion with the demolition permit notification of the senior building official. Currently, the process that we go through, because there have been some problems with demolitions previously, is that the applicant applies for the demolition permit, which they had, but in order for it to be issued, it has to be signed off by multiple departments, including mine, and that's when this whole thing goes into action. I would say that whether or not there has been a formal letter to the building department has not probably taken place, because we haven't sort of seen the necessity for that, because we have to sign off on the building permit anyway in historic preservation. So we sort of protect it underneath that that process. So perhaps that's something that needs to be re-examined in terms of how that's written.
Right. Yeah, my
But-
concern, Ms. Najee, my concern is that the IDO is very clear on that language, that it requires the building official to get notice. And if notice is not given to the building official, and it says in writing, makes it very clear that a demolition can proceed under, I guess, under other standards, which I'm not privy to. But it seems to me that at the very least, because this is a city council piece of legislation and it is their directive through the IDO, that at least it should be followed in form to some extent. And if the language needs to be rewritten, well, that needs to be addressed in a different forum, but
Correct.
it's required in this IDO. So, and then if it's not done, obviously then the demolition can proceed. And then you have those balances still, those checks and balances with planning staff where you have to sign off. But it seems to me that it needs to be done. So you're telling me that there is no written notification that was sent to the building official?
No,
Okay.
there was not.
Then because if there was, I would have requested that into the record, but I won't do that. So thank you.
The other thing just that I will add in terms of the way this case was viewed is it was their request not to have the 120-day review period. We had spent 2 months prior from the time that they had originally made their application for the demolition permit. I was speaking with the property manager for the site, and we had been working on those alternative means of what to do, what we would normally do in the 120-day period, so that we could try and relocate the building, which seemed like the best alternative for that.
I think we've lost the connection with
Just
you.
lost her.
Yeah.
Just wait.
Let's wait a second and see if she comes back
But
up. Here
because
she
of the
is. Ms. Najee, we lost you for a moment. Can you repeat what you said in the last 30 seconds? Oh, we lost her again.
Sorry,
We lost you again.
you're not able to hear me?
No.
Oh, I'm sorry. I'm going to turn my camera off so I can, because my microphone doesn't work well
Got
on
it.
my computer.
Okay.
Sorry.
That's fine. Can you repeat what you said in the last minute or so?
I was saying that from the time that the applicant had applied for the demolition permit until it was heard by the Landmarks Commission, that we had spent that time, I had been working with, I believe, the property manager for the site to try and find an alternative as far as relocating the property. And of course, that's in the record. And that is basically the sort of thing that would be done during that 120-day review period if it was invoked by the Landmarks Commission. We found that the size of the building just made the cost and the fact that there's no company in town that was capable of moving that structure, that it was cost prohibitive to move the structure. And therefore, the original staff report stated that to proceed with demolition. I think the Landmarks Commission felt like, why are we reviewing this if there's nothing we can do? And so with the idea of that 120-day review period off the table, which they just should have invoked it anyway, I would say. They did not feel comfortable just saying demolish it. And that was how we got here.
Right. No, I read that. I read the record at the hearing record. It seems to me that they were trying to negotiate some level of preservation for that building with the new plans, which normally that could be considered impermissible contract zoning. But I think that it's permissible in that case because there are exceptions for negotiation for the Landmarks Commission, and they do have that implied authority. I'm not worried about that. I guess what I'm worried about is that by their denial, they essentially used more authority than what they were given by the city council. They don't have authority to deny, whether or not the applicant requested it or not. That authority is not in this IDO. And I was trying to find a place where it might be implied in the IDO, because most agencies of the city, most quasi-judicial agencies in the city have authority to approve or deny or table. But there's an exception carved out with the Landmarks Commission that gives them more specificity in what their purpose is, what their authority is, and that would be under 66B. So I guess I'd go back to Mr. Gleason. Are you finished, Ms. Najee?
Yes, I am. Thank you.
Okay. Mr. Gleason, do you have any questions of Ms. Najee?
No, I don't have any questions.
Okay, thank you. And Ms. Najee, I don't have any more questions of you as well. I am considering, I'm strongly considering sending it back, remanding it back to the Landmarks Commission to do one of those three things. They have to do something that they're authorized to do. A denial is not something they're authorized to do. And I know that seems a little strange. And I looked, like I said, I looked for their authority to deny, and I couldn't find it. And I reviewed the entire IDO again to see if it could be implied from the other sections of the IDO. And it's just not. It's not. This section is very clear, and it carves out their purpose. And they don't have, in that purpose, they can only do one of those three things. So, Mr. Gleason, are you asking for a remand?
I would like to ask for a demolition permit, but I don't think that's within your purview either. So,
well, I can recommend it to the
Yes.
city council, but then it's reviewed by the city council. But it seems to me that if the Landmarks Commission exceeded their authority and they didn't look at entirely what they were supposed to, it would be my I just think it's just better that a remand back to the Landmarks Commission, and it doesn't have to go to the city council for a remand, so you don't have to wait for that. But I think, unfortunately, Mr. Gleason, I think the delay, I know you were trying to avoid a 6-month delay.
Of course.
But I think that you were part of the problem by asking for a decision, and so I think you created that delay. And so I probably will remand it with some instructions to the Landmarks Commission to do one of those three things, and then you can appeal that decision as well if you need to. But if they follow their authority, which is pretty broad in those three things, I don't see how an appeal would work. But anyway, ma'am.
Oh, I'm sorry to interrupt, Mr. Chavez.
Okay.
I'm just respectfully, I'm just wondering what the 120 days will offer. As Ms. Najee mentioned, for several months prior to the hearing, we did that due diligence of investigating alternatives for moving the to another site, and so all of the things that would normally happen under that 120-day purview have been reviewed, and it has already been determined that those options aren't feasible economically. And I think the Landmarks Commission already made it pretty clear that they're not comfortable issuing a demolition permit. So I think going back to the hearing is just going to delay this further and not take it in any direction.
I agree. It's going to delay it in any direction. It seems to me, though, that the Landmarks Commission, if they invoke the 120-day period, then there are other issues besides just moving the structure, feasibility of moving the structure, and economic feasibility of preserving the structure. The other option is whether or not the city wants to designate it as a landmark. They have that authority to do that under this ordinance. And so that's something that they would look at. And I can see where you're going, that they're not going to do that because of the cost, certainly. That's an issue. But that's what that 120-day period requires. And then if nothing is done, no negotiation has evolved into something concrete, the ordinance requires that demolition occur. If the 120-day period lapses and nothing is done, unfortunately, that's the IDO. I'll consider making a recommendation to the city council But I can tell you that my recommendation seems to me that the city council would invoke the 120-day period. Because
That's my concern too, that we go to
Yeah.
council and we just get bounced back to landmarks, or we get bounced back to landmarks commission at that point.
Well, I think we have an option. I mean, there is an option.
Ms.
It's
Najee?
Leslie Najee, yes. I think there is the option that we can get you onto the May agenda if it's remanded back to the Landmarks Commission. And we can present, you can present to them, looking at options in terms of, as we had spoken in the commission about, like allowing salvage of key elements of the property that are in very good shape, maybe looking at even
I don't
showing a
think they
different.
can do that. I don't think they can do that. That's the problem. I don't think they have that authority, because again, they only have the authority to do one of three things, and it doesn't include negotiation at this point. I don't see that as part of their authority. They don't have, and you would have to be careful with that authority. I mean, if the Landmarks Commission is negotiating as they were trying to do in the last hearing, in the way they were trying to do it, you're setting the city up for legal liability. And I don't want to go into that right now, but I can tell you that I don't think they have that authority.
Well, I'm not saying for them to do it. I'm saying for the applicant to make as part of their proposal.
Right.
That in order to sort of pay homage to wanting to preserve elements of this property, that part of their application is demolition to do this, not for the Landmarks Commission to say, you have to do this.
Okay.
But I'm saying that the Landmarks Commission may feel more comfortable with giving you the demolition permit at the next hearing if you put forth more demonstration in terms of even like the costs that we found in terms of trying to relocate the property and things like that. But I can discuss that with them later.
Ms. Najee, I don't want to go into that because
Sure, I understand. Sorry.
That's something. No need to apologize. I mean, this is the reason why I'm allowing all this discussion, is because this is a new section that hasn't really been tested at this level, to my knowledge. And so it's very elaborate. It's an elaborate section that has a lot of language in there that is not routine for other agencies. And so I think that I would leave that to the applicant to deal with the Landmarks Commission. I will give very detailed instructions to the Landmarks Commission under this ordinance, only under this ordinance. I'm not going to exceed my authority. But I think that a remand is necessary at this time, and I can't apologize because it's the ordinance. But yeah, it doesn't. If they invoke the 120-day period, now they can fast track that. I mean, they can go to demolition. You can go to demolition with the city, it sounds like, through some sort of negotiation at an earlier point within that 120-day period. But that's between the applicant and the city at that point. So. Am I making sense? I hope so.
You are to me, yes.
Okay, Mr. Gleason.
Chavez, if we do go back to the hearing, can we request that legal counsel from the city be present, just to make sure that any negotiations that are presented by Landmarks Commission can be immediately at least overviewed or reviewed by legal counsel to make sure that that's
that's an interesting question. I don't know if I have that authority to request that counsel be present. I can recommend it, certainly in the remand. It seems to me they should have a real estate attorney there with the city, because I was when I was reading the minutes of the hearing, they were starting to go into an area that was, in my opinion, it was troublesome legally, and because of the authority given to them under this IDO. And so I would worry about them going into that again. But I will give very detailed instructions on a remand, and hopefully we can all learn something from this. Okay.
Yeah.
Ms. Facio, Mr. Gleason, do you want to finish up with the rebuttal? There's really nothing to rebut, but you have that opportunity.
No, I have no further comments at this point, Mr. Chavez.
Ms. Facio?
I have no further comments at this time. Thank you, Mr. Chavez.
Ms. Naji, is there anything you would like to add before we go off?
No, I'll just talk with the applicant when they're ready to contact me to see how to move forward. And
thank you for putting together a very detailed report. I thought your report was very detailed and well explained. So you did. Thank you. I review a lot of planning reports, and definitely yours is very good. So I will get this out as quickly as possible, and I will send it simultaneously to the city with the applicant. And Ms. Naji, I will include you in the list. Ms. Naji, I don't have your email address though. Could you give that to me? Oh, never mind. I do, because it's in the master list for the Zoom call, correct?
Yes, it should be.
Good. I've got it then. Thank you so much. Okay, we'll go off the record.
Thank you.
Thank you, folks. Have a great day.
Yeah, it's always illuminating to have a hearing with you, Mr. Chavez. So thank you very much.
Good to see you too, Mr. Gleason.
Okay.
Bye-bye.